Hello, everybody. Thank you all for joining us on this webinar, U.S. Supreme Court Preview. This is Matt Fitzgerald at McGuire-Woods in Richmond, and as you may know, we've been doing this now for several years in a row, and I always appreciate the panel members that we have. We have some rotation this year in our panel, so I'll be sure to introduce everyone. If you have questions, I think there is a portal you can type them into, and we will see them. So we will just weave the answers in as we go along. And let's go ahead and get started. Our panel today is first Ashley Peterson, who is an associate here in the Richmond office, a former clerk to Chief Judge Carnes of the 11th Circuit, an excellent associate here and member of our Appeals and Issues team with significant following of the Supreme Court, as trained by Judge Carnes.
That's right.
Brian Schmalzbach, a partner here at McGuire-Woods. He has been a regular on this program, and we welcome him back. Thank you, Brian. And Ben Hatch, a former clerk to Justice Scalia, who also has been a frequent contributor. Ben practices in our Norfolk office, and recently, perhaps most famously and recently, was a part of the team that successfully ended the prosecution of Aaron Schock, the former congressman from Illinois. Welcome, Ben.
Thanks, Matt.
All right. So, and also I clerked for Justice Thomas years ago. Thank you. So for the first, at the beginning, I normally talk a bit about setting the stage, what's going on this year in the Supreme Court, and what has gone in the past to set the stage for this year. And we'll have a little bit of discussion before we get into the actual cases that we're previewing. So the first thing that happened, some people may have missed this, it went by fairly quickly, but Justice Stevens died at age 99 this year. A very notable justice of the Supreme Court, extremely long-serving. And, you know, one thing that comes up a fair amount about Justice Stevens is his movement to the left. Perhaps he was somewhat left when he was appointed by President Ford in 1975, but he's one of the great examples of justices sometimes nominated by Republican presidents who over time have sort of moved to the left, and pretty clearly by late in his career was regarded as sort of the liberal lion, a mantle that basically was handed off to Justice Ginsburg when he retired. And although she seems to have attained somewhat more fame and cult following, you know, he was the sort of Ginsburg before Ginsburg, and he passed away. He retired in 2010. So of the panelists here, I think Ben is the only one who may know him from his time on the court.
And
Brian?
This is Brian Schmalzbach. Well, a thing that's interesting about Justice Stevens is he's sort of a bridge figure between sort of older 70s, 80s, 90s style living constitutionalism and what is now more common in the Supreme Court in constitutional interpretation, which is originalism. And the opinion that makes this most clear is the Second Amendment gun rights decision in Heller, where Justice Scalia, writing for a 5-justice majority, held that the Second Amendment did protect an individual right to keep and bear arms, at least inside the home. And the dissent, a very long, very detailed, fairly methodologically sophisticated opinion by Justice Stevens, went into a lot of the same originalist sources, using a lot of the same originalist techniques that Justice Scalia used, but came out the other way. And I think that that opinion really paved the road for a lot of liberal originalism now, and made it, it sort of validated originalism as a methodology that everyone needs to be conversant in.
So you're saying that he embraced that framework and just used it to come to a different conclusion, sort of reflects the victory of originalism in a sense, that he was even willing to fight on that field versus to say, like, forget it, who cares about that?
Exactly. I think, who knows in his heart of hearts whether he truly believed that that's the right way to do it, but he recognized that that's now how it has to be done.
Yeah. I think Justice Stevens, go ahead, Ben.
I was just going to say, one of the things about Justice Stevens that was probably less noted, but I always thought was interesting, is, many advocates, when they get up to the Supreme Court level, when you write your cert petition, you focus on whether there's a circuit split often, and you're very focused on what the circuit courts or the state Supreme Courts may have said on an issue. But then if your case actually gets granted, often the justices are not so interested in what the circuit said because they're going to rule on the issue. And so the briefing switches to a matter of first principle, focus on Supreme Court cases. And Justice Stevens was, I think, one of the few justices who from time to time would actually pay attention to whether there had been a long-standing, consensus among the circuit courts on an issue, and would appear to give that some weight in cases. In other words, that if the law had been more or less settled, there was a consensus among the circuits, not to say he would defer to them, but that would be something he would recognize in cases where many justices would not even really point to that. And I think that's an interesting thing with some of the cases we'll be talking about later today. Justice Gorsuch in the oral arguments has made a point of asking counsel about reasoning from dissenting and majority opinions in lower court cases. So he at least seems to have also, taken up a focus on more so what some of the circuit courts are saying in the cases than maybe other justices.
Yep. All right. So another thing that's going on with the Supreme Court now, sort of in the background as far as the justices are concerned, is the discussion among the Democrat candidates for president or hopefuls for president about changing the structure of the Supreme Court as some of them maybe politically as a reaction, obviously, to what happened with Justices Gorsuch or perhaps Judge Garland, and then Justices Gorsuch and Kavanaugh. But it's interesting also in that it taps into a discussion that had already been happening, maybe in the dark rooms and the corners a little bit, about the proper structure of the Supreme Court and the way that it should function in our government. So I'll put up a few things that have been said by the various candidates in answer to this question in open debate. I think it is notable in this group that really the eldest statesmen of the Democratic Party are the most hesitant over any sort of idea about changing either the size or, say, creating term limits on Supreme Court justices. Biden and Sanders have been the most against it. The others are much more open to these things. But beyond the political debate even, there have been for a long time suggestions that tinkers could be made to make the Supreme Court a little less perhaps political, or maybe just to recognize that it's political and live with that. So one idea that has been floating around for a while is that Supreme Court justices should serve 18-year terms, so that every president basically appoints two. There are some potential issues with that constitutionally. Brian, did you have a thought about that?
Sure. I mean, the Constitution says that the justices shall serve during good behavior, and that's long been interpreted to mean life tenure. I think there are now some academics and others trying to socialize the idea that maybe good behavior doesn't mean life tenure, but it's going to take a big shift in the mainstream thinking to accommodate anything other than a constitutional amendment to make a lot of these changes.
Right. I mean, so expand, if the pure proposal is to expand the size of the Supreme Court, to change the number of justices, that I do not think would require a constitutional amendment, because it doesn't require there to be 9 justices. Presumably, Congress could pass a law and the president could sign it that would say it's going to be now 11 or 13 justices or something like that. But with the idea of term limits comes this concern about good behavior, and one of the ideas that I've heard floated for that is essentially that when they're finished with the 18-year term on the Supreme Court, they rotate back down or down to the circuit courts of appeals, so that they're federal judges for life, essentially, for good behavior, but just the part of it that's on the Supreme Court is more limited. And I think it could be very interesting to see whether any of these get traction. I mean, obviously it's politically a very hot potato, but in the perfectly imaginable world where sort of the Democrats sweep in the next few years, there could be quite serious debate about this, I think. So, this slide I like to put up every year just to remind everyone what we're looking at and how old the various justices on the Supreme Court are. Obviously, January 2021 is the inauguration of the next president, and after that, the next term after that. So just to see how old each of the justices are now and how old they would be, and those sort of gives you a sense of the likelihood of the next president or the next presidential term having more seats to appoint, to nominate at least, on the Supreme Court. One thing that jumps out at me about this is that Justices Thomas and Alito are actually quite similar in age. We don't normally think of them that way because Justice Thomas has been there so much longer, 13 or 14 years longer than Justice Alito, but age when appointed has a lot to do with it, of course, and so they actually go down in a pretty steady stream down to the youngest, and it's now fairly well entrenched that the proper age for appointment to the Supreme Court is essentially the young 50s, if not younger, if you could get away with it. And so they really are setting up these situations where if, say, the Justice Gorsuch of today live to be as old as the Justice Ginsburgs, you're talking about 30 and 40 years on the court. So, any other thoughts on age or the ever-marching progression of time on the justices?
Well, I do think it will be interesting to see whether some of these justices that are appointed in their early 50s decide to retire versus, continuing their lifetime appointments, as you say, for the whole march of time. Having a 30-year tenure in a position would be pretty considerable.
Sure.
So I think, it would be interesting to see if there are other Justice Kennedys in the world that maybe, despite their importance to the court, decide that they're ready to retire.
I think that's a great point, and another unusual thing about where the justices are coming from now is that they are all professional lawyers by trade, and it's interesting to see some of a progressive group recently put out a sort of model list of potential justices to respond sort of to what Trump did before the 2016 election, and a lot of those floated potential justices are not necessarily professional lawyers. Some of them are politicians, for example. And if we see a more diverse group of justices, diverse by profession, appointed in the future, that might make it more likely that they would not want to sit on the Supreme Court for 30 or 40 years doing the same thing for the rest of their lives. They may have more interesting things to do, like some previous justices did. The first Chief Justice left the court to go be governor of New York, so we may see a return to that.
Yeah. Yeah, and it is true that in the, even though I think we would say that the last handful of justices who have been confirmed are very political in terms of how hot the fight was and how much it was disputed whether they would get through, the closeness of the votes in the Senate, that they are very, not even really just professional lawyers, but those with significant experience on the Court of Appeals. Kavanaugh was there on the D.C. Circuit for like 10 years. Gorsuch was on the 10th Circuit for a number of years. Kagan obviously is the exception to that, but as you say, Brian, highly professional lawyers for whom this is sort of the obvious end game, more so than they might be. Another thing we like to do before we turn to the cases is talk about some statistics from last term, which we pull with all proper respect, which is a lot from SCOTUS blog. But there are some interesting statistics from last year. This one is strength of the majority, and it shows the percent of the time that each of the justices were in the majority. You can see here, this is another way to cut some of the statistics you sometimes hear about, oh, well, a quarter of the cases are unanimous. Sometimes it's more than a quarter that are unanimous. Basically, you can see that even justices who disagree with each other a lot wind up in the majority, a great majority of the time, in terms of what they ultimately think, how their votes stack up. So as political as it gets, we're not exactly approaching the end of times in terms of every case comes down to a 5-4, and it's all about which party they were nominated by.
And so what's missing from this list is obviously Justice Kennedy, who would routinely be in the 90s or even 100% of the time in the majority, because he ended up being a true swing justice. The court almost always went the way he did. And I think you're seeing now that there's not as much of a consistent swing justice, either because of the ideologies of the personnel or because of the cases that they're taking. The court is composed of shifting coalitions that aren't as consistent Justice Kennedy +4 as in previous terms.
Right. And the other thing you can see on here is Kavanaugh with only 64 votes, he's still coming in. That was his first most term, and so this year will actually be his first absolute complete term, and I think that will be interesting to see whether he holds up there as the most, or does it sort of go to Roberts, who has widely been reported as the closer thing to a swing vote now. Questions during the argument. The oral arguments, as many people know, have become thoroughly infested with questions. They can be quite telling in what the court thinks. They lead to a great deal of reporting. Oh, the court seems conflicted about this, or court seems likely to do that. The most interesting overall thing that's happened with questions in the argument is that over the summer, the court got together and decided that they were going to self-impose a rule that counsel who came to speak were going to get 2 minutes before they would be interrupted by questions. So basically a gentleman's rule among the justices that they were all going to be quiet for the first 2 minutes of everybody's argument. And it's worth noting that is some of these cases have 3 and 4 people speaking, particularly when the government will be involved. So 2 minutes at the beginning of everybody's talk is definitely a meaningful opportunity for the court to listen. Notably, just a handful of arguments into the new term, Justice Sotomayor perhaps forgot about the rule and cut in after about 30 seconds of one lawyer's speech. Chief Justice Roberts immediately jumped in and said, no, answer that question after you still get your 2 minutes, please. And that's the latest reporting today on an immigration case that's been argued.
In the chart on the left, you see Justice Kagan so far has been the 4th most active questioner, which is a change from previous years. I think she really took her role as the junior justice pretty seriously and tried to limit the number of questions that she asked. And now that there are a pair of more junior justices, she may be coming out of her shell a little bit, which is not necessarily a bad thing at all. I think most Supreme Court advocates would tell you that she is one of the most effective, and if she's hostile to you, dangerous questioners on the court. And so we may get to see more of her effective questioning style as time goes on.
Yes. It's interesting to note, too, I mean, they're basically in categories. Sotomayor, by a meaningful margin, asks the most, and when she talks, she asks meaty questions. She spends a fair amount of the argument time talking. Then there's this group of them who are roughly, call it 18 to 13, and then at the bottom, Justices Ginsburg and Thomas talk the least. There's been no recent talk of a streak again for Thomas since it's only been a year or two since he has commented in an argument, but his overall average sits at 0. And one thing about Justice Ginsburg, too, is that she often tries to get in there with her questions early, ask her a couple of questions, and then sit back and watch the others go. So that's her style. This is the number of opinions issued by the justices last year. There are a few notable trends on here. For the last few years, in the absence of Justice Scalia, Justice Thomas has particularly found a voice. I actually started doing that while Scalia was still there, but it's more remarkable without Scalia up there writing an almost similar number of opinions. He writes a lot of concurrences and dissents. Some of them are very short, and they just say, as I've expressed before, I don't believe in this category of the law for this or that reason. So they're not all particularly long, but Thomas is the most prolific. And notably, so early in his tenure, Justice Gorsuch, showing a particular proclivity for writing dissents and concurrences. I note that Justice Kagan, as a good example of, for several years, the most junior justice herself, hardly ever wrote a concurrence and normally wrote dissents only when she was assigned that on behalf of a block of justices. She has continued with the trend of not speaking alone terribly often, but it's an interesting contrast between her and Gorsuch in their first few years on the court. I don't know if those on the right feel the need to comment more, but it seems that they do. All right. So we'll turn now to the future of the court, current term and beyond. There have been some comments about what this court is going to be. The overall tenor is that this is going to be a blockbuster term, and we're going to talk about that in a lot more detail. We can sort of go right through it now, but the court has granted some really interesting and hot-button issues this term. It's also been a bit punctuated by the presidential politics. Obviously, as we've discussed, there is a great polarization, and there are a lot of people running for president right now. And so it could be a very interesting time to have a very interesting term on the court. A lot of major politically appearing decisions coming down in June of this year, I think could play a big role in the ongoing race. This is a fairly famous quote from Chief Justice Roberts, who vigorously refuses to acknowledge that the outcomes from the court reflect a political basis. And I think, to some extent, he's right. I don't think that the court does see things in political terms. I think he's right that they don't. But it's so tough in the polarized environment and in the relatively few cases that we all focus on to get away from the idea that the divide is ideological and to pull the judicial differences apart from the political ones. So the first case, we're now going to talk through in a little bit of detail a handful of cases that the Supreme Court has granted for this term, and first the DACA cases.
Sure. So imagine you were an administrative law professor and you felt underappreciated, underrecognized, and you wanted to create a presidential administration that would increase the importance and prestige of your line of work. You could hardly do better than the Trump administration because it has made administrative law issues front page above the headline news almost from the beginning. And this is one of the most important Trump-era administrative law cases. And the background for this case starts back in the Obama administration. And after Congress did not pass the DREAM Act, which would have given statutory protection to undocumented immigrants who are brought to the United States as children, President Obama decided to accomplish very nearly the same thing by executive action. And so he created this policy called Deferred Action for Childhood Arrivals, or DACA, which would have done the same thing. It would have given work authorization and prevented deportation of so-called dreamers who were brought here, as children. The idea being that they are here illegally through no fault of their own, and so they deserve some protection against deportation and the ability to lead more of a normal life in the United States. So that's the beginning. And then President Obama later expanded DACA to a policy called DAPA, Deferred Action for Parents of Americans, which provided similar benefits to an enlarged group of people. And that case eventually made its way up to the Supreme Court during the Obama administration, or near the tail end of it. And what happened there was that a lower court had enjoined DAPA, the second policy, and held that it exceeded the president's authority and that it was not a valid exercise of his prosecutorial discretion. President Obama framed the policy as there is too much deportation and immigration enforcement work to do, so we are going to prioritize certain cases and necessarily deprioritize certain cases. And so DAPA and DACA were both deprioritizing, as he framed it, enforcement of the immigration laws against these particular classes of individuals. So we get up, the law is enjoined, so it's enjoined nationwide, and DAPA makes its way up to the Supreme Court in a case called Texas v. United States. United States v. Texas. And something unexpected happens. Justice Scalia passes away. And that ends up being hugely important for the future of that law because the Supreme Court ends up splitting 4-4 on whether to uphold that injunction against DAPA. And what happens when the Supreme Court splits 4-4 is that the lower court's decision is affirmed, but it has no presidential value for the Supreme Court. So that takes us to the Trump administration. And President Trump in 2017 decides to revoke DACA and not to continue that policy of prosecutorial discretion, not applying the immigration laws against the people who are covered by DACA. And what's important here is the explanation he gives for that decision. Primarily, he says there are concerns, and then Attorney General Jeff Sessions, there are concerns whether DACA was ever lawful in the first place. And great evidence of that concern is what happened to DAPA on its way up to the Supreme Court. So a few district courts in various circuits grant injunctions preventing the administration from revoking DACA. And then the federal government does something unusual. The United States Solicitor General seeks what's called cert before judgment. They try to take these cases up to the Supreme Court even before a court of appeals has ruled on them. And that is something that this administration's Solicitor General's office has done far more frequently than has ever been done before. And the Supreme Court says, no, we're going to let some of the courts of appeals weigh in first. The Ninth Circuit then does eventually affirm that nationwide injunction, and so up we go to the Supreme Court, which does grant cert. And this case will be argued in early November. And so there's two issues. One is, does this case belong in court at all? Is the revocation of a policy on prosecutorial discretion subject to judicial review at all? The administration says no, this is purely a matter of executive discretion, courts have nothing to say about it. And the second question is, well, if courts do have something to say about it, was the decision arbitrary and capricious? And the argument there is essentially that the administration revoked DACA on the pretext that it is unlawful, when the real reason is they just don't like it as a policy matter, which, reading between the lines, is of course true. And so what I'm looking for in this case is how the Chief Justice pivots from his decision in Department of Commerce versus New York, which was the census case that dealt with whether the Department of Commerce could add a citizenship question to the census. And there, the chief wrote a very surprising opinion which says, yes, the government can add the question, it's within its power, but we think the government essentially lied about why it added the citizenship question. And there's sort of a similar dynamic in this case. And so normally Chief Justice Roberts is fairly deferential to administrative agencies when it comes to respecting the explanations they offer for their own policies. So we will see if he returns to that tendency in this case.
I see that you are predicting that the government is going to win this one. And I share your prediction on that. And something that I thought was interesting as I've been following this case is some of the amicus briefs that have been filed are sort of fascinating. The Cato Institute has filed an amicus, and pretty conservative organization, and they've sort of openly acknowledged that their position is that they would support a policy normalizing the immigration status for Dreamers, right? And I think that's something that many people can sort of acknowledge socially, right? That these folks who were brought here as children and have grown up in the United States, I think a lot of people acknowledge that deporting those individuals seems a little harsh, and that it makes sense to perhaps deprioritize those populations of folks. But their position was that Obama nonetheless exceeded his executive authority by trying to force this through in an executive order when it wasn't able to pass as a bill in Congress. And they quote Justice Scalia's statement that sometimes policies or laws may be stupid but still constitutional, which is one of my favorite Scalia quotes. And they say that this one sort of falls into the flip side of that coin, which is a policy that may make good sense and be something we support as a general matter, but yet be unlawful. So it'll be interesting to see if that thread gets pulled on by the court at all.
So do we think that the federal government would have been better off in this case if they had essentially just admitted that we're going back on this policy because it's a Democrat policy and we're Republicans who have been elected now, and so we're just taking it back essentially for the same reasons that they had discretion to do it? Like, do you think that sort of trying to in a sense, hide behind the legal doubt about whether it could be done is actually a risk for them?
Yeah, I think that's exactly right. I think that's a major risk. There are certainly questions about the lawfulness of DACA in the first place when President Obama instituted the policy. But one of the most important parts of the Obama administration's defense of DACA is that this is just my prosecutorial discretion. A future administration won't be bound by this and can revoke it, and that's why it's lawful now. And if the Trump administration had taken its predecessor up on that offer, it would have removed a lot of the justifications that the lower courts have seized on to enjoin the revocation of the policy.
Right. And because it's easy for the court, in a sense, to say, well, you say you doubt whether it's lawful. I'm a court, so I'm great at deciding whether things are lawful. I decide that it is lawful. What's left of your justification? Now it looks arbitrary and capricious when sort of admitting it's a political football, might have even gone better. But either way, the prediction is that government will prevail. All right. The Malvo case. Ben?
Yeah, this is a case where the facts are, I think, of great interest to many of us who live in Virginia. And the law is probably of great interest only to a very narrow subset of Fed court nerds. So let me try to break those apart here. The Malvo, in the name of this case, comes from Lee Boyd Malvo, who many of you may recall that name. He was one of the two so-called DC snipers who back in 2002 for several weeks terrorized the greater DC metropolitan area, including in Virginia and Maryland, by randomly killing people in various places, including shopping center parking lots and that sort of thing. I was in DC in 2002 when this happened, and many of our listeners may be as well. And for those who weren't, it got to a point where you would see people as they left their apartment buildings to go to their cars in the morning, kind of walking hunched over and walking in diagonal, going back and forth because everyone just didn't know where the next attack was going to come. So it really created an atmosphere that, fortunately, I think has not since been recreated. And ultimately, Malvo, along with his accomplice, were captured, and Malvo received multiple life sentences in Virginia for his crimes. And those sentences were fully lawful when they were imposed, even though at the time he committed the crimes, Mr. Malvo was 17 years old. Now, you fast forward, and the Supreme Court has since then issued a number of decisions under the Eighth Amendment about what types of penalties are appropriate to impose on juvenile offenders, such as Mr. Malvo. And ultimately, in a case called Miller versus Alabama, that happened in 2012, concluded that it's inappropriate to have mandatory life sentences for juveniles because, the judges need to be able to consider whether juveniles are permanently incorrigible, is the language they use, and thus might merit a life sentence, or whether their crimes reflect the particular circumstances of youth and may not merit a life sentence. And the way that the law works is that that decision in Miller would have applied to any case that was pending either in a trial court or on appeal at the time it was decided. But that decision would not have applied retroactively to cases like Mr. Malvo's that were already concluded. So then in a subsequent case, Montgomery versus Louisiana in 2016, the Supreme Court said the rule of Miller is a rule that merits retroactive application, even to closed cases, so that you could bring a habeas petition and try to overturn your sentence if your sentence violated Miller, even if it had been final at the time before Miller was decided. And here, Mathena is the custodian, and so Virginia is effectively on the other side of this case. And Virginia's argument is that under Virginia law, a judge always has the ability to suspend part of a sentence. So even if the sentence is a life sentence that the jury recommends, a judge always has the discretion to suspend that sentence, and therefore Mr. Malvo's sentences were not mandatory life sentences, and therefore the rule of Miller does not apply to him, and certainly doesn't apply retroactively, and therefore his sentencing was appropriate. And so it's one of the interesting things that comes up in this case is that when the Supreme Court decided Montgomery, some would say, restated what they decided in Miller in a way that expanded what Miller said to make it sound like at least the Supreme Court was recognizing that judges have to be able to consider not just whether it's mandatory or not, but the judges have to consider these factors of youth and incorrigibility, and that's part of what's required retroactively. And Virginia's argument is that, no, you can't. You have to take Miller and take its application retroactively. You can't kind of add to that rule in the case that decided whether it was retroactive. And the case was actually argued just yesterday, and in support of Virginia, the Solicitor General of the United States also argued in support, and I thought it was interesting that in the argument, a Assistant Solicitor General named Mr. Fagan was arguing, and he actually used the term that the Supreme Court in Montgomery fudged what it had said in Miller. And I think Justice Scalia, who dissented in Montgomery, would have probably used agreed with that term or something stronger. But I thought it was interesting to see the Solicitor General using the term fudged to describe a Supreme Court decision. It's also interesting that and this is actually a fact that is consistent on several of our cases today, that the Solicitor General's office is defending a position in the Supreme Court in this case that was different than positions it took not too long ago in the Obama administration. And so they also got asked about that. Why have you changed your position on this issue? Ultimately, much of the argument was focused on issues that I think were not really the issues of retroactivity, and it seemed like some of the justices were kind of struggling with the record of the case. But at the end of the day, I think Virginia will win this round. I think the case will be remanded back to the Fourth Circuit to consider whether Virginia's sentencing scheme is really one that was non-mandatory at the time that Malvo was sentenced. And if it was non-mandatory, then even though he got a life sentence, the sentence will probably be upheld ultimately.
So thanks for that, Ben. I think this case is also going to be an interesting test, not only on how Justices Gorsuch and Kavanaugh approach the Eighth Amendment, but their approach to stare decisis in general. Many conservative originalists view the Eighth Amendment line of cases, starting with Roper and Atkins and leading eventually to Miller and Montgomery, as some of the worst sort of living constitutionalist, evolving standards of decency cases around. And so it'll be interesting to see how these two new justices deal with that. I think one approach, which some of Justice Kavanaugh's questions and argument suggested he might be interested in, is reading Miller and Montgomery really narrowly and saying, well, as Virginia was sort of saying, as long as there's a chance for a judge to make a sentence non-mandatory, we're not going to construe Miller to extend to that. There's also the option of saying just Miller was outright wrong. I think that's the approach that might be more tempting to Justice Thomas, certainly, but potentially also to Justice Gorsuch, who wasn't on the court for Miller and may not be willing to attach his name to an opinion that implies that it's good law. So stare decisis is another big issue that will come up in the opinions, I think.
Yeah, good point, Brian.
Thank you. County of Maui.
Yes. So County of Maui is an interesting case. It involves a dispute over the Clean Water Act, and specifically over a provision that requires a permit whenever a pollutant is discharged from a point source into navigable waters. And specifically here, the County of Maui has a wastewater treatment facility that has 4 wells, and the county takes treated wastewater and injects it into the groundwater surrounding the facility to dispose of it. And that wastewater, I think all of the parties in the case agree that some portion of that wastewater eventually makes its way through the groundwater and into the Pacific Ocean, which is a navigable waters under the Clean Water Act. And so the question is really whether that discharge into the groundwater can be seen as a discharge from a point source, the wells, into the navigable water of the Pacific, even with the groundwater in between. And the Ninth Circuit has said yes. They basically said that because the treated wastewater was fairly traceable to the Pacific Ocean, it was essentially the functional equivalent of a discharge directly from a point source into the Pacific Ocean. And there's a pretty clear circuit split on this issue now. The Fourth Circuit has issued an opinion that agrees with the Ninth Circuit's interpretation, this sort of functional equivalent idea. And the Sixth Circuit has explicitly disagreed with those decisions and reached the opposite conclusion. And there seems to even be some disagreement, perhaps, among various federal agencies about how this provision of the Clean Water Act should be interpreted. The Solicitor General has filed an amicus in this case supporting the county position, and there's several EPA administrators have filed an amicus brief saying that the Clean Water Act has always been interpreted by that agency as covering discharges through groundwater like the one at issue here. But ultimately, the case may not even be argued. It's set for argument in just a couple of weeks on November 6th, but there's some indication that it has perhaps been settled, sort of an unusual situation. There's several letters that have been filed with the clerk of the Supreme Court, and they're available on the docket. One from the Wildlife Fund saying, hey, we've settled this case, court, you should dismiss it, not hear argument. And then there was a letter from the county attorney saying, no, we haven't settled the case. And apparently there's some disagreement in the County of Maui internally about who has authority to settle the case, whether the county council can settle it, or whether the mayor has to approve of the settlement. And so there's a little bit of infighting happening on the Supreme Court docket via letters right now.
So it seems to me that what's happening here is the County of Maui is afraid that it might win?
It sounds like it. Like they maybe don't want to have their name attached to an opinion that could say, this these that could basically be seen as harming the environment, I think, right?
Yeah, that's right. I think this dispute about who the petitioner is, who gets to decide whether they've settled or not, is something that has been coming up a lot in the Supreme Court in the sense of the problems that arise when you have divided government. And you saw this a lot in the last couple of years in the Virginia voting cases where, the legislature that passed a law is from a different party than the Attorney General that is responsible for enforcing and defending the law. And so you get up to the Supreme Court and all of a sudden no one is defending the law that the legislature passed. And there's a similar dynamic here where I think the court is going to be wary of accepting at face value an assertion that, we're going to make this case go away, because I think that would invite a lot of gamesmanship in similar divided government scenarios where a party that is afraid of how the Supreme Court might rule would try to take steps to prevent the court from hearing it, for example, by refusing to defend the law or by trying to approve a settlement. So I am no expert in Hawaiian local government law.
Right.
I'll defer to Matt on that. But it wouldn't surprise me if the Supreme Court either asks for additional briefing on this or asks the Hawaii Supreme Court to address the issue. But I would be a little surprised if they got rid of the case just because somebody who claims to be a party claims to have settled the case to make it go away, because that would invite mischief in the future.
Right. And I think it is a very interesting setup. I think the divided government point is a great one, that this sort of thing could happen a lot, but just the exact scenario here where, obviously it's in the interest of the county government as a government not to be regulated by the Clean Water Act. And so they've pursued the case and gotten it all the way to the Supreme Court, but then they realize, oh wait, we're not just a county government, we're the county of Maui, like this is a very liberal government in a very liberal state, and they're almost afraid that they're going to win and ruin the law because they're litigating against these environmentalist groups who may have significant support from the actual populace in Hawaii. So a fascinating one. We got a question very quickly about why the Supreme Court granted cert in the Malvo case, because it can't be that sort of thing applies to a lot of people. I have a brief thought about that. My understanding is that there are something like a dozen prisoners in Virginia who were sentenced arguably in the same sort of category as Malvo, where it's arguable whether they had any discretionary things. So a dozen in Virginia alone suggests there could be a reasonable number across the country. But another thing that I look at there is it was Malvo who prevailed in the Fourth Circuit, and Virginia got cert granted. And so that to me suggests it's not so much not necessarily a concern for the well-being of those in Malvo's position, but that a right-leaning court may be interested in backing down on some of those fairly controversial precedents favoring prisoners that had come out when Kennedy was on the court.
Yeah, and I don't think you should discount just how high-profile this particular litigant's case was at the time. I was a senior in high school when this happened, and I remember driving around and there would be like giant tarps hanging off the edge of gas stations so that you couldn't see people when they were standing still gassing up their cars. And I think a fair number of the clerks at the Supreme Court and most of the justices who were in and around D.C. then, that probably made an impact on them. So I suspect this case caught their eye.
Yep.
All right.
And I think,
yeah. Go ahead.
And last thing on that one I would just say is that the Fourth Circuit's decision said it didn't matter whether Virginia's sentencing scheme was mandatory or not. And that seemed, even though I think there still was a lot of discussion around that at the argument, it seems like a fairly crisp legal issue, as you were indicating, for those who are interested in thinking, and maybe trying to narrow the applicability of some cases that they wouldn't have agreed with if they'd been on the court. that seems like potentially a good opportunity to start that process in that case. So turning to Bostock and Zarda, and then another case to follow, are very interesting cases under Title VII. Bostock and Zarda are cases that present the issue about whether discrimination against an employee because of sexual orientation constitutes prohibited employment discrimination, in the words of Title VII, because of sex. And it's an interesting case and obviously a consequential case. It's one of the interesting aspects is that as a matter of statutory interpretation, it kind of comes to some first principles of statutory interpretation, text versus intent. Text, because there is a fairly straightforward textual argument for why what the type of discrimination that occurred here is because of sex. And the argument goes like this. If I'm a man and I want to date or marry another man, I'm fired by my employer. But if I'm a woman who wants to date or marry a man, I'm not fired by my employer. And so it must be because of sex, because if a man does it, he gets fired, and if the woman does it, she doesn't get fired. And so it must be because of sex. It's discriminating between the two sexes. It's a fairly straightforward textual argument about why it's because of sex. Many of the countervailing arguments are that, and this seemed to be widely accepted, I think, among the judges and in the briefing, that when Congress originally passed this language in 1964, it would not have considered discrimination based on sexual orientation to be a type of because of sex discrimination. At that time, homosexuality or acts related to it were actually criminal in many states. And so Congress would not have intended that to be part of it, or maybe would not have thought of it. But the argument against that is that, well, we interpret the language they use, and the fact that Congress may not have thought of this doesn't mean that the language they used doesn't apply to it. And it's a very interesting thing. The case was argued on October 8th that I think my reading of the transcript is that Justice Gorsuch was very attracted to that statutory argument, that, whatever Congress intended, this language would appear to apply to it. And so my read was he seemed likely to vote in favor of the employees, and that there are probably enough votes for the employees to win. Another funny little side note about the case is that former Judge Posner had commented at one point that the court should just take opportunities to update statutes like Title VII to make them apply to sexual orientation discrimination, because it was, essentially, who wants to wait for Congress to do it? Courts should just, update statutes. And the counsel for the employees, Ms. Carlin, was none too eager to kind of adopt that formulation of the argument. And at one point, as Judge Posner's comments kept getting deployed against her, she referred to him as a loose cannon. But in any event, I think that the employees will win in this case. This is another case where the Solicitor General's office actually switched sides and argued on behalf of the employer at the Supreme Court, now under the Trump administration. I'll just pause if there's any other comments on that one before I go to R.G. Harris Funeral Homes.
I just think it's interesting that this textual, I think we often see textual arguments being deployed by, or have seen them being deployed by, more conservative justices for perhaps more conservative outcomes. So it's interesting to me that this case is one in which the textual reading seems to support what many would consider to be the more progressive outcome in the case, right?
Yeah.
No? Do you disagree?
Go ahead, Ben.
Well, I was just going to say, and Justice Scalia actually authored one of the principal Title VII decisions that, applied the statute in a way that Congress likely would not have intended, but in his view, was in the scope of it. So I agree that, what many would consider a conservative justice, but following the text,
Right.
Has reached that conclusion under Title VII.
Yep.
So turning to R.G. Harris Funeral Home, and I know we're running short on time, this is a case, and it was argued the same day as Bostock and Zarda. This one presents the question about whether discrimination based on transgender status is a form of discrimination under Title VII, and specifically also whether it's a form of sex stereotyping under the Price Waterhouse versus Hopkins decision. And I would say, again, this case has already been argued, and much of the argument turned not on the actual facts of this case, but about concerns about how whether this would, impact separate sex bathrooms in the workplace, if this type of claim was recognized. And there was much discussion about separate sex bathrooms. There was also discussion about, Justice Alito brought up about whether if this form of discrimination is recognized, whether that would affect Title IX, essentially requiring that transgender athletes be allowed to, compete on the team of the sex with which they're identifying. I think at the end of the day, the majority opinion in the case is unlikely to go to those issues which are not squarely presented in this case. And here again, I think my prediction would be this is a case in which the employee wins, and it is recognized that this is a form, at least the facts of this case are a form of discrimination that's recognized by Title VII.
Great. Thanks. So we have a couple more. We will run through them in sort of a lightning round because we can spend a couple more minutes, I think. We did get a question which raises a good point about the County of Maui case. Should that case be settled and disappear or be determined that it has disappeared? There is a case that the Supreme Court is currently holding called Kinder Morgan from the Fourth Circuit, which raises a similar sort of groundwater and water flowing over the ground. When can it qualify as a point source? Paul Clement represents the company that's bringing that appeal, and that is on hold. I think there is a good chance that the court could eventually decide to grant that case if it decides that Maui is a bad vehicle. So let's go to a 1 or 2 minute lightning round on the last couple that we have. New York State Rifle and Pistol.
Sure. So this is notable because it will be likely the first Second Amendment case that the Supreme Court has heard since Heller and City of McDonald. Heller, which recognized an individual right to bear arms under the Second Amendment, and McDonald, which incorporated that right through the Bill of Rights so that it applies to the states. What's lurking in the background of this New York case is the question, how far outside the home does the Second Amendment protect an individual right? I would be a little surprised if the court reaches all the way out to address that, but there are important questions about what tier of scrutiny applies, whether it's strict scrutiny of the sort that applies to racial classifications or limitations on free speech, or whether it's intermediate scrutiny, which seems to mean something different in just about every case, and the way the Second Circuit applied it here means not much at all. But the most notable thing about this case is that the Supreme Court received a very punchy amicus brief from Senator Whitehouse that asked the court to dismiss it as moot because after cert was granted, New York City repealed the law in what I think is fairly understood as an attempt to avoid a Supreme Court decision on this case. And so the parties will be fighting about whether it's moot or whether there's an exception to the mootness doctrine, such as voluntary cessation, that would allow the court to hear it. But Senator Whitehouse basically told the court, people will think you are very political if you don't dismiss this case.
A very threatening brief, huh?
Nice Supreme Court you got there. It'd be a shame if something happened to it.
Fair enough. All right. And the last one, June Medical Services versus G.
Speaking of potentially thinking the court's political, this is the first abortion access case that will be heard since Kennedy retired and since Justices Kavanaugh and Gorsuch joined the court. So obviously, first opportunity for the court to consider this obviously always hot button issue following this ideological shift. And the interesting thing here and what to watch out for is that, the court just held in Whole Woman's Health versus Hellerstedt in 2016 that a Texas law requiring abortion providers to have admitting privileges at nearby hospitals, the court held that was unconstitutional and that because it was a burden on the right to abortion access. And the Louisiana law at issue in June Medical is identical to the Texas law, but the Fifth Circuit acknowledged Whole Women's Health, but decided that the Louisiana law was distinguishable on the facts, basically saying that the plaintiff in that case hadn't proved that the abortion providers couldn't get admitting privileges, and also hadn't proved that even if they were unable to obtain those, that it would close a significant amount of clinics in order that would be required to show an undue burden. So I think the thing that most people have been looking to and trying to read the tea leaves on is the fact that Chief Justice Roberts earlier this year voted with the liberal justices on the court to stay the Fifth Circuit's mandate in this case, pending resolution of the appeal, which, given some of his public statements about his concerns over the integrity of the court and stare decisis, it'll be interesting. I think folks are wondering whether maybe he will move more toward the center, as you all have mentioned earlier in the presentation, whether, maybe he will try to take on that swing vote that Justice Kennedy has relinquished.
Great. All right. Well, thank you to our presenters for discussing these cases, and I think we all look forward to a fascinating Supreme Court term ahead. If anyone has any questions, they should feel free to submit them to us, and we'll try to respond to you, but we are going to close down the webcast. So thank you very much, everyone.